Hello and welcome to the Texology. I am CA Priyanshu Goyal and this audio episode is part of my podcast series The Texology, which aims at imparting information on crucial concepts of Indian taxation scenario. If you prefer to listen in Hindi, you can watch my videos on YouTube and Instagram. You can find my profile by the name CA Priyanshu Goyal. As like other episodes in this series, this is going to be a very short clip with the aim of conveying only relevant matter. Before we begin with today's content, I would just like to mention that if you feel like connecting with me, I am available on Instagram, LinkedIn, Twitter by the name CA Priyanshu Goyal. Today we are going to discuss that what will be the date of acquisition of property for the purpose of indexation given the scenario where allotment was made in a certain year and then several payments have been made in different years following the allotment year. The issue was discussed recently in the case of Ms. Renu Khurana versus ACIT International Taxation by the Honorable ITET Delhi bench, wherein the residential flat was allotted to the assessee-wide allotment letter dated 12th December 2005. Thereafter, beginning from financial year 5-6 till financial year 14-15, the assessee has made payments toward purchase of the flat. Assessee executed the apartment buyer's agreement with the builder on 4th of August 2010, falling in financial year 2010-11. DRP directed the assessing officer to allow deduction towards indexed cost of acquisition on payments made from financial year 2010-11 onwards. Honorable ITAT in the given case held that in the allotment letter not only a specifically identifiable residential flat was allotted to the assessee, but the assessee had made payments in accordance with the terms and conditions of the allotment letter. In circular number 471 dated 15/10/1996, CBDT has clarified that in respect of flats allotted under the self-financing scheme of Delhi Development Authority, the date of issuance of allotment letter would be considered to be the date of acquisition of property. This is because allotment is final unless it is cancelled or the allottee withdraws from the scheme. In the given case also, Honorable ITET said that the allotment letter issued by the developer builder is final, as it is in the respect of a specifically identifiable property and has ultimately culminated in execution of the apartment buyer's agreement in financial year 2010. Therefore, it was held that the date of acquisition of the residential flat has to be reckoned from the date of allotment letter, and benefit of indexed cost of acquisition should be available to the assessee based on the payments made from the financial year 2005-6 and not from the execution of the apartment buyer's agreement. So that's all for this clip. I hope you'll find this useful, and if there is any related query or question about this, feel free to reach out to me on info@priyanshugoyal.com.